Welcome to the Impact Stage. We have Michael Williams. He is a California licensed attorney and partner with Clym, a leading global consent management platform. Prior to joining Clym, Michael was the chief financial officer at Conference Direct, a global meeting planning company, as well as a senior attorney with Ernst & Young. Michael is a graduate of the University of Connecticut School of Law and received an MBA from Bryant University. Michael currently lives in Los Angeles. Speaking today on CCPA, the data privacy law changing the U.S. marketplace. Please welcome Michael Williams to the Impact Stage.
Thanks, Trevor. Good morning, everyone. I should say good afternoon to those visiting from Eastern Europe. As much as I would like to be there today and visiting Cluj in Romania, I'm happy to do this from Los Angeles, but happy to have everyone here. On that note, just want to say a quick thank you to Texylvania for doing an amazing job transitioning and pivoting this event to being virtual. As someone who's worked in the conference planning world previously, I know how heavy a lift that is, and they've done a great job. And I just wanted to say thank you because you know they're in the midst of all this COVID stuff, they're doing a fantastic job. I'm going to share my screen so you can see my presentation. As Trevor mentioned, I'm Michael Williams. The photo was clearly taken prior to COVID because I'm wearing a suit. As I can tell you from walking around the streets of Los Angeles, people are not dressing this way anymore. It's mostly pajamas that I see in the outside world. So hopefully sometime soon we'll get back to a sense of normalcy. The topic for today is CCPA. Now, I'm going to talk for about 15 minutes about the law, about challenges businesses face, that sort of thing. What I would really love to do is spend quite a bit of time answering questions from people in attendance. Feel free to drop questions into the chat, and we can answer whatever you have once I'm done speaking. I feel like that is the best way to understand the law when you have real life questions from the audience. So just to get started, what is CCPA? So CCPA is the California Consumer Privacy Act. So this is California's answer to GDPR. It's the most comprehensive data privacy law thus far that has been implemented in the United States. It's brand new. It was effective January 1st, and enforcement just started about 12 weeks ago. So companies, if they have not gotten compliant, now is the time to do so, because this law is very similar to GDPR, which has been in effect in Europe for just over 2 years, and is really changing the landscape for how businesses handle consumer data, how they are supposed to protect that data, how they're supposed to process that data, that sort of thing. CCPA is often referred to as GDPR light because it does affect a smaller number of businesses. However, it's very important as an initial step for the US to really modernize its approach to data privacy. And there are some additional new concepts that it has put forward, such as do not sell, broadening of the term sale, that sort of thing that we're going to dive into, that businesses all around the world need to pay attention to in order to avoid the significant financial penalties that CCPA can cause. So we're not going to walk through this entire chart, but the point of it is to say that there's no, although CCPA and GDPR and other data privacy laws around the world are very similar, there are significant differences between them, so that those companies operating on a global scale, those companies who are selling to European residents, who are selling to California residents and others, need to understand that there's no one-size-fits-all solution to global data privacy. There's no one way to do this. If you are selling to different jurisdictions, if you're collecting data from consumers in different geographic locations, you need to be aware of the data privacy laws that exist in those locations. Now, this is the biggest question that potential customers of Clym have. Do I actually need to comply? Now, there are some bright line thresholds that exist regarding what kind of companies need to comply. the big takeaway here is that this is an or test. You don't have to meet all three of these thresholds. You just need to meet one out of the three to be subject to the law. Number one, if you have annual gross revenues in excess of $25 million, you're in scope. If you collect and process personal information from at least 50,000 consumers, you're in scope. If you derive more than 50% of your annual revenue from selling personal information, you're in scope. Again, most people think this is an and test, it's an or test. And the key takeaway here is that if you're selling to California consumers, it's likely that you're in scope. And one of the reasons is personal information is extremely broad under CCPA. So a website visitor's IP address is actually considered personal information. So if you have relatively significant traffic to your website from residents in California, that can put you in scope if you exceed 50,000 website visitors from California on an annual basis. So that's a pretty significant issue. The primary considerations, we consider there to be three primary considerations when it comes to data privacy within CCPA. Consent is the first one. One of the real big differences between GDPR and CCPA is the concept of consent. Under GDPR, Europe's law, it's an explicit consent jurisdiction. What that means is if you want to collect my data, I have to tell you that's okay. I have to provide affirmative consent and say, you are able to collect my data. California is the reverse of that. It's called an implied consent jurisdiction. What that means is that companies are able to collect data, but they have to provide me as a California consumer the ability to opt out, to say you can no longer collect my data, you cannot sell my personal data, that sort of thing. Additionally, it introduces this concept, number 3 there, do not sell my personal information. Billions of dollars of revenue have been accumulated by Silicon Valley companies and others by selling personal data. CCPA includes an extraordinarily broad definition of what's considered a sale. So generally people consider a sale, I give you $5, you give me a cup of coffee. That's a sale. And their CCPA considers a sale to be a transfer of data or any valuable consideration. So if you are using any kind of cookies such as Google Analytics or Facebook Pixel or things like that, where you are receiving a service such as Google Analytics allows you to analyze data received from your website visitors, you are receiving a service in exchange for transferring that data. And that can be considered a sale for purposes of CCPA. That's a big deal because now companies who don't sell data like a Facebook or a Google or things like that can be in scope for purposes. It's a real big deal here. One of the other things, a pro tip here, we like to call them, is while those of you visiting from Europe will often see these cookie banners saying, do you accept cookies? How do you want to handle those things? CCPA does not require that sort of thing. Again, because it's an implied consent jurisdiction, you don't need that explicit consent up front. However, you do need to provide consumers with a mechanism to opt out. Policies. So most people think of this as the privacy policy. One of the big things here is to be clear in your communication. So if you are collecting information, you need to let people know what you are collecting, how you are using that data, are you selling that data, that sort of thing. And you need to provide that in a clear and transparent way. You can't bury it in a website or try to hide it from consumers. You need to be clear, you need to be transparent, and you need to provide a mechanism for consumers to opt out of that collection and sale of personal information. CCPA also includes a requirement that these policies be updated on an annual basis. So every 12 months, you will need to update your privacy policy and others if you want to achieve compliance with CCPA. The third primary consideration is this concept what's called a DSAR, or a data subject access request. So what this means is CCPA has enumerated certain consumer rights. So I have the right to request that a company delete the information they've collected. I have the right to ask what data the company has collected on me. I have the right to request the company to not sell my information. This is where companies get themselves into trouble most frequently. Individuals will make a request and say, I want to know what data you have on me, let me know. And they don't have a mechanism to track those things. They're doing it in Excel spreadsheets. They are doing it through email. These are not scalable solutions. And if you have, that's okay if you have one request, but if you have 100 or 1,000 requests, it's going to be very problematic. So DSARs is something to familiarize yourself with so that you don't run afoul of this particular part of the law. Providing consumers with a way to exercise their rights is very important under both GDPR and CCPA. So I like talking about myths. A lot of people assume they know things about CCPA or other regulations that are often not true. The first one is that this was a law to rein in abuses by Facebook and Google and things like that. It's not. It affects a number of companies, both inside and outside of California, across a wide range of industries. It affects hospitality, travel, real estate, the list goes on. And companies really, because so much data is collected in 2020 in modern times, companies really need to get a handle on what data they're collecting, how they're processing it, that sort of thing. This is not a big tech issue alone. It's an industry issue. The second big misconception is CCPA only applies to companies who are actually located in California. This is not true. In a global economy, data is being collected on a daily basis, and California has the 6th largest economy in the world as its own individual state. So many companies sell to California consumers regardless of where they are in the world. If you're collecting data from California consumers, you're likely going to be in scope for CCPA, regardless if you are located in Los Angeles or London or Lagos. Number 3, my company doesn't sell personal data. Again, the transferring of information through tracking scripts or cookies can be considered the sale of personal data, so be careful there if your website uses tracking cookies, and most do. Number 4, my company is compliant with GDPR, so that means it's compliant with CCPA. Not true. There are nuances in the law. There's no one-size-fits-all approach here. Number 5, we don't meet CCPA thresholds, so we don't need to comply. Again, going back to the 3-part test, you only have to achieve or exceed one of those thresholds. So most people say, well, we don't make $25 million. We're not there. The reality is that if you have a website that's collecting IP addresses and through cookies and tracking scripts, you're probably going to be in scope. Other big question we get from customers, we've seen that GDPR has not really done a great job enforcing penalties. Only certain companies have been affected, and they're only really tech companies. So does the CCPA have teeth? And the response there is, what do all of these companies have in common? They're all different industries. Some of them are California companies. Some of them are located outside the U.S. Some of them are small. Some of them are large. The thing they all have in common is that they've already been sued for CCPA violations. And that's a big deal, given that enforcement has only occurred for the last 12 weeks. And the penalties can be severe. So there's 2 ways that companies can suffer from CCPA violations. Number 1, the state can come after you. The Attorney General's office is authorized to impose penalties for intentional violations up to $7,500, unintentional violations up to $2,500. That's per incident. So if you have 100,000 customers where you've had violations, that can be $2,500 times 100,000. These numbers add up extremely quickly. Additionally, individual consumers can file lawsuits against companies that violate CCPA. And this is where it gets real tricky because number one, the cost to defend these lawsuits is extraordinarily high. Number two, there are so many consumers in California that can file these lawsuits. And for those who don't reside in America, Americans love suing people. So we expect litigation to be extraordinary on these violations because the penalties can be so severe. And one of our when I was explaining this to one of our customers, they said, "So what you're telling me is that getting compliant will cost me something, but being non-compliant could cost me everything." And I thought that was a great way to put it, so that's why I've included that as the key takeaway for this slide. Also, California is experiencing extreme budget issues. We don't have enough money to fund operations, and so right now is a time where the Attorney General is looking at CCPA as a potential moneymaker for the state. I'm going to run through the next couple of slides very quickly because I want to allow time for Q&A. These are common challenges that we see customers have. The big one here is manual processes. If you are handling your compliance through Excel or Word or Microsoft Office tools, you're going to be in trouble because those things are not scalable, they're not time-stamped, that sort of thing. So when an auditor or regulator comes knocking on your door, it's going to be a real problem for you. Specifically now, so much additional data is being collected through people working remotely, that people getting their body temperature scanned at restaurants and office spaces and things like that. So much data is being collected. These are common business challenges during COVID-19. So especially now, companies should have a heightened awareness of data privacy issues that arise based on these new protocols and procedures and kind of the new way of life that we have everywhere in the world. What's next for the US? We have a lot of problems in America getting things done at the federal level. So oftentimes these regulations are left to the state. So this is a chart from a few months ago detailing where things are now, where things are going to go. And I can tell you that when it comes to regulation, California is often the canary in the coal mine. And what that means is that what California does, because the economy is so large, other states follow because it's just easier to comply with what California is doing because of the size of the economy. So this has happened with the environment, with gig workers like Uber and Lyft, and also with tobacco consumption. Regulation that starts in California oftentimes goes to the other states. So it's really important to understand that these regulations are just it's a matter of time before they get implemented in other states in the US. Just to do some additional information here about how companies, especially Clym customers, handle their data privacy. So Clym is a consent management platform. These are all the things that we do to help companies comply with these data privacy laws. So we hit on the big pillars: consent management, policy management, DSAR management, that sort of thing to ensure long-term compliance. I have an X through this one on the left. So this is what you often see. What companies think is correct compliance is telling a consumer that this page uses cookies. There's a big X there for a reason. That is the wrong way to do things. The concept of consent comes down to choice. If I'm using a tool like this, I don't have choice. The one on the right is what Clym's tool looks like. And this one allows people to exercise those choices. There's a lot more going on, but in an effort to keep this simple, we can show how flexible a tool like Clym can be to enable companies to comply with these laws. Another thing we talked about, you really should not be using Microsoft Office tools to do this. You need a timestamp solution. You need something that's flexible to accommodate these laws in different jurisdictions. So having a tool that allows you to do that is extremely important, especially as your business grows. And this is true for all aspects of CCPA, especially DSARs. There are deadlines. If I make a complaint or a request to a certain company in California, that company needs to comply with these things in a certain period of time. Doing those things in a non-timestamp fashion is going to lead to a lot of problems. And I know we ran through those last couple of slides quickly because we have 10 minutes left, and I wanted to open up this time to answer any questions that you may have, and I'm here to help in any way that I can. So thank you for your time today. So I believe Trevor is going to come back and join us in 2 minutes.
Or now.
Or now. Look at you, 2 seconds. I should have said 2 seconds, Trevor.
So did you? Maria has a question here. Did you see it? Or am I? So Maria asked, "Thank you for the presentation. What will be your advice for startups who are not situated in the USA, but their primary market is the USA, to avoid the issues with CCPA and stay up to date?"
That's a fantastic question. Thank you, Maria. So as I said before, so we work with we partner with accelerators and incubators all in Europe and also in the US, because we feel that startups are best served by achieving compliance early in their life cycle, so that when you achieve scale, you don't have to implement it at that time, right? And there's a couple different reasons for this. Number one, when you're looking to raise a seed round or a Series A or things like that, the diligence now includes data privacy, right? So this is a big part, because investors don't want the liability or the potential liability that exists with violations. So the advice that we would give, if you have US consumers, or if you are planning to sell to US consumers or collect the data from US consumers, it's really a great idea to implement data privacy protocols early on and choose a consent management platform to assist you with this that's cost effective and scalable. I mean, in early startups, cost is always an issue, so finding one that's cost effective and scalable that can scale with your business is extremely important.
Cool. Thank you.
Mm-hmm.
So I have a quick question for you while people take some time to write theirs, if there's any more. So this is only, what you're talking about is only applicable to California, right?
The law, right, in the CCPA affects data being collected from California consumers.
And so what is keeping these tech companies from like having their headquarters in California, as opposed to I don't know, moving somewhere else where they wouldn't have to comply if it becomes too costly, as you said?
They'll still need to comply, right? So this is what's called an extra jurisdictional law. So because the data originates in California, that's where the law applies. So if we get this question a lot from companies that even outside the United States. So we have a ton of European customers who sell to the U.S. And even though they might be headquartered in London or Cluj, and you're selling to U.S. consumers or California consumers, or if you're collecting data. So if you have website traffic and you get a lot of traffic from California, you're likely going to be in scope. So it doesn't matter necessarily where you're headquartered. It's not like a tax law where these laws. It's the same thing with, this is why GDPR was such a big issue in the US 2 years ago, when US companies that were collecting data on European residents had to comply with GDPR, even though they had no physical presence in the EU. Same thing with California. And with California being the world's 6th largest economy, it's a big deal.
I was about to say, forget the United States, California is the 6th largest economy in the world. So, you're going to want to do business there, so you're going to have to comply with this law. And I said, and when did this, I know you probably went over this, but how long did this law take to write from start to finish?
Good question. So it was proposed in 2018 originally, and it became effective in January 1st, 2020. Now, the thing to keep in mind here also, and this is true with other data privacy laws that are continuing to develop around the world. So for instance, Brazil has, I think they're the 9th largest economy in the world. They last week approved their own data privacy law. So these things are occurring all over the place. And one thing to keep in mind is California's CCPA was effective as of January 1st, And by the time they started enforcing in July, there were 3 changes to the law that had already taken place. So in 6 months, the law changed 3 times. So businesses were scrambling, and we did a lot of work on our end to ensure that our customers were covered in terms of compliance. But that's one of the challenges that we see companies having, is it's so hard to keep up with these laws. It's almost impossible to do so internally.
I was going to say, a lot of people in Romania will have sympathy for that because the country is ruled by emergency ordinance. So literally tax laws and business laws will change overnight, and it wasn't even talked about publicly. And when you're running a business, you're forced to have to comply, and it's completely overwhelming. So I think a lot of people have sympathy for that. But we have a question from Bogdan. He says, thank you for the presentation. Do you think every state will come up with a law of its own, or will the U.S. end up creating, I guess, a general one federally?
It's a great question. It's something that we think about daily. We have in the U.S. we have challenges getting anything done at the federal level for a number of reasons, and so because of that, states have kind of taken ownership of data privacy within for their own states, for their own residents. So even, for instance, Texas, which is very much known as a business-friendly regulation, like a very, very, very regulatory environment. Last week, they came out and said that they're going to be considering a data privacy law in 2021. So our expectation is that the federal government is unlikely in the short term to enact a law. I think as you see this becoming more, there's a heightened awareness around these things, you might see the federal government act on a countrywide U.S. privacy law. In the short term, I don't anticipate that happening.
Yeah, I think if you saw them interview Mark Zuckerberg, that law is not coming anytime soon to our congressman. It kind of flies over their head, this whole domain.
I would agree.
Yeah, I mean, like the average age is like 95 in our Congress right now, but soon, we will have to accept the future.
Totally, and that's why it gets really difficult as well. And this is why, so Clym uses geolocation technology to say, so we can identify customers coming from California or Texas or Florida or wherever they're coming from, so that, that's how using a flexible consent management tool is incredibly important, especially if you're trying to comply with all of these various regulations. And again, in the U.S., we don't anticipate the federal law applying all 50 states, and because of that, it's going to become a very complicated framework in the U.S.
Yeah, and this is just for everybody, for the EU, for the United States. It's a whole new world with taking these constitutions or laws written 100 or 200 years ago and trying to apply them to a domain like the internet that.
Oh, hey, totally. We posted an article last week about Japan, whose data privacy law was from 2005. And I was like, you guys remember what 2005 was like? I had a flip phone.
Yeah. And
Amazon was not Amazon, and Facebook was in its first year and only available to university students in America. This is a whole new world that we're living in, and so much more data is being transferred and processed, and countries are starting to understand that data is extremely valuable, and they want to provide protections. I mean, in California, one thing I did not mention is that in November 3rd, when we vote for the president and senators and things like that, there's another privacy measure on the ballot, so that we may have to deal with another privacy law just in California. So this is what we're, this is when we say it's an ever-evolving data privacy landscape, that's what we mean. These laws are ever changing, and different jurisdictions are taking different measures.
Yeah. Well, Michael, thank you so much. We unfortunately are at the end of our time here, but it was great to have you at Texylvania, and we hope to see you next time in person.
In person for sure, and thanks again to Texylvania for doing a great job, and everybody there, they're doing well.
All right, thank you guys. Thank you, Michael.
Thank you. Bye.